is Elizabeth Townsend. It is April 4th. This is our second interview with alumni. This is Michael Meehan, and we're talking about his experiences today. All right. Well, why don't we start, so I'm sort of going through your CV. So why don't we start first with what was it like being here? We'll just do this briefly in terms of legal education. Now, because you went to University of Arizona, and we're going to be talking a little bit about what you think legal education should do. So maybe we could do that. We can even do that a little bit together. But sort of what your education was, and sort of what you think legal education should be at the law school itself. Do you have any? Or we can come back to that question.
You're just asking kind of
a broad thing, like for instance, like law school here right now is very friendly and not very. There's not a real sense of like that sort of. It's not, I mean, it's scary, but it's not super scary, and sort of the philosophy is much kinder, and there's lots of clinics and sort of all those sorts of things. Sort of the atmosphere they're creating is very, very kind. And
well, when I started law school, I think I was among the first, not the very first class, that was smaller in size, and it was not the previous program of look to your left, look to your right. At least one of you, and maybe two of the three of you, are not going to be here. It was, if you're admitted, we expect that you'll be able to handle the curriculum and be able to graduate if you do your job and so forth. There was certainly a high level of concern the first year. Will you be able to learn the law? Will you be able to pass the exams and so forth? But I wouldn't say it was an intimidating atmosphere. Certainly, it was not the sort of unduly competitive, cutthroat environment that I have heard and read about other law school classes of other places at that time and maybe since. It was much more we're in it together kind of an atmosphere. There was not as many clinical programs. There were a couple of clinical programs. That was something that was starting to be talked about. It was recognized, I think, as a good thing to do, and there was a little bit of opportunity, but it wasn't as developed as it is now. It was much more the casebook method and the Socratic method. And again, there was a fair number of seminars as well, but the sense that I have is that there weren't as many seminars, that there are more seminars now than there were at that time.
Professor Ayers was also second in his law school class, and I interviewed him last week. And I asked him if he thought of himself as perfect, because the people who are first and second, the rest of the class think of them as being perfect. And he said that no, he got a C in this class, and this happened to him, and he didn't feel comfortable with this class. And I wanted to know, sort of, did you see yourself as perfect when you were second in your class? Or?
No. To begin with, that first semester, I got the only C that I got, and so I started out with the expectation that I was going to have to scramble for whatever I could achieve in terms of academic performance, and then to perhaps give the best example of where my thinking was about whether I was accomplishing as much as I could or wanted to or not. When I took the bar exam, and I walked away after completing the bar exam, I really was uncertain whether I'd passed the exam, and I ended up scoring the top score on the bar exam. So I really didn't have a sense of where I was in terms of comparing myself to others.
Interesting. And what was your strategy after you got the C? Did you change anything in terms of studying, or did it scare you, or?
It worried me. I can't say that it changed anything. I just worked hard, listened carefully, and showed up.
All right, let's move to Justice Rehnquist. This is supposed to be sort of to help students and sort of to give them a sense of what it's like to do things. And one of the questions I had was sort of, what was your daily work like when you were working for him?
Probably the largest amount of time was spent reading certiorari petitions and writing cert memos. Because when I was a clerk, each chambers separately read and briefed their justice on the certiorari petitions. There was not a certiorari pool like there is now. I think that there are either 7 or 8 members of the court now that receive the same memo from one law clerk who is part of what they call a cert pool. So we spent a lot of time reading certiorari memos, and many of them could be distilled onto one page. The lawyers writing the cert petitions probably wouldn't like to think about that, but that was certainly my experience. Some of them would be 10, 15, 20 pages if they were real complex. So that was a very large part of it. Then secondarily, we did research for cases that were going to be disposed of on the merits, argued and decided in that. And there was a lot of individual work, but there was a fair amount of interaction with the justice and briefing him on things. And being briefed to a fair degree about the work of the conference so that you could do your work. So it was a contained group. We had 3 clerks, and I think the chief still has 3 clerks, even though I think he could have 4. And it was a close-knit group. And it was very, very satisfying.
You've done a lot of appellate work, and did this have anything to do with doing your work with Chief Justice Rehnquist? Is that where did it make you want to do that more? How did you get interested in that?
I think that there was a desire to do more appellate work because of the clerking that I had done. I think that my law firm also gave me opportunities to do appellate work that I might not have had if I had not had the clerkship. So it was a little bit of a symbiotic situation.
And when I look at all of the different cases that you've done, or at least representative cases, they're all on all kinds of things.
True.
And I wanted you to talk a little bit about sort of what it is to do appellate work and sort of what the skills are. And I mean, we just got through talking with a trial lawyer, and he was very specific, and this seems very broad in the sense of that you've got so many, in terms of topics, and sort of what that is exactly for students who don't really know what that would be like to. And also, I guess one more thing is when you started it and sort of how you got involved. Did you just start it right after you finished the clerkship?
The first case that I argued to the Arizona Court of Appeals actually occurred on the day before I was admitted to the bar. The law clerks for the firm that I ended up becoming a member of for a period of time before I graduated, and had worked with the trial lawyer on a case and had essentially done the appeal. And so I was admitted pro hoc vice the day before I was admitted to the bar and argued a case on the standard of care for a parent with a juvenile that's getting in trouble on the day before. So I really started right out of the box.
Oh.
Part of my breadth, I think, is a function of the fact that I started practicing in Tucson, Arizona in 1971, and even the then largest firm in the city, which was the firm I joined, which was then called Robertson and Fickett, had a very broad-based practice. And I was the only lawyer hired that year. And so I did appeals, I did trials, I did some tax work, I did all kinds of things. And so sort of inevitably the appellate work that I did covered a wide range of things. And it wasn't all that different really from what the trial work was that I did as well. But I suppose if you start doing more and more appellate work, there are special skills that can help you to be successful in doing appellate work. And you can take those skills and apply them to a broad variety of subjects. And you also have the luxury of some time to read the record below, read the law, and kind of become an expert in this particular area, and then write the briefs and do the arguments. So you can go from one subject to another, to another, to another, in a way that if you're doing, lots and lots of cases that you're preparing and trying, in short order, you don't have the luxury of learning.
One of Dean Massara's favorite questions that she seems to want me to say a lot is sort of cases that you wish you had done differently or that you lost sleep over. Are there any appellate cases that are that way that you can think of?
Appellate cases that I wish I had done differently. There really aren't any appellate cases. I mean, I could think of some that I perhaps could have done better. One recently where I was so intent upon convincing the Arizona Supreme Court that it should exercise its discretionary special action jurisdiction that I wrote a long, complicated brief. And one of the things that the duty justice said to me when we were arguing the stay and the jurisdiction was, well, how can this be a clear abuse of discretion if it took you 55 pages to write your brief? I mean, there are those kinds of things that you look back on. But there's no case at the appellate level that I can think of that I really wish I had made a major difference in my approach, or argued differently, or selected different issues, or things like that.
Do you think that's different because they're appellate cases? Do you think that there's something about the appellate cases versus other kinds of cases that would make that the case?
Well, the one thing that probably would contribute to second thoughts about handling cases at the trial level that you don't have so much of at the appellate level is the much more intense interaction with the client, working with the client, advising the client, preparing the client to be a witness, and so forth and so on. And there are a couple of trial cases where I wish I had been able to do a better job advising the client and getting the client's confidence. And that's not, I mean, when you go to appeal, the record is there, it's set. You read it, you select from it, you read the law, you write the brief, and it's a lot more structured and contained.
Do you have any other thoughts before we move on to another topic on appellate cases and things like that?
No, I don't think so.
Okay. All right. The other question I wanted to talk about, if this is okay, is the difference between trials, mediation, and arbitration.
Sure.
We're going to be talking to different people who do those in different ways, and sort of what that is and what you think about those forms.
Okay.
So we can just sort of generally maybe start with just what you think about those three in terms of if you had a case, where would you want it to go? Would it depend on the case, or would it depend on the forum? Do you like one forum over the other?
Well, if I had my druthers and if it made sense to the client, I'd always rather try a jury case. It's just more interesting, more challenging, there's more dynamics, there's more potential for unexpected, exciting things to happen. The human conflict is more sharp. It's just more professionally pleasing. But jury trials are a luxury that few can really afford, in the sense both of the time and expense involved, and in terms of the lower level of predictability of the outcome. I mean, I believe strongly in the jury system. I would much rather, generally speaking, have more than one trier of fact be deciding my client's case. And yet, because every jury is composed differently, until you get into the courtroom and select the jury and look at the 8 or 12 individuals, you really don't even have a clue what the case is likely to be like and how the jury is likely to come out. Pragmatically, and sort of in a longer-term institutional sense of things, I have become a huge fan of mediation in the last 10 years. Mediation combines two, I think, real important things for clients. One is, lots of times a client wants to go to court because they want to have their say, they want to tell their story. And sometimes they get a chance to tell their story, and if they don't win, they're not as devastated by losing as you might think. I mean, usually they are, but oftentimes they're not, because they've had a chance to tell their story. They've had a chance to express themselves. And mediation doesn't provide the same opportunity, as much of an opportunity. I mean, you don't get on the stand and have it, or even without being formally put under oath, you don't have the client tell the whole story and so forth, but they do get a chance for their case to be discussed, to be presented. They view the mediator to a degree as sort of an audience and not simply a facilitator of the discussion. And then secondly, it gives the opportunity for resolutions and solutions that you might not have if you go to court. And what really sensitized me to that benefit was a series of intellectual property ownership cases that I mediated. And one of them, one of the earliest ones in the 1990s, involved probably either 7 or 8 opposing parties, all having some role to play in whether a particular piece of biotechnology belonged to my clients or belonged to somebody else, and what had happened and so forth. And if we had gone to trial and tried it to a jury or a judge, the outcome would have been either my folks owned it and they were entitled to so much money, or they didn't, and it was just sort of one alternative or the other. Whereas with the mediation, we could get various people to contribute some money or not contribute money, and to take a piece of the technology or not take a piece of the technology. And I had that pattern repeated at least 2 other times with biotechnology cases and the ownership of technology cases. There was one case that I had in which I represented some university professors who were the inventors of some really pretty interesting what they call bioseparation technology. They had a lot of potential applications, and this had been their professional career. They had built their doctorate or postdoctorate reputations in the scientific community on that, on their developments. And they felt that a competing company was simply trying to acquire money by claiming ownership, and they were never ever going to give up ownership. And they figured that the other side, all they wanted was money, and they just wanted to defeat them. And if we had gone to trial, that's what it would have been. We own it, or we don't own it. We went into a mediation, and a lot of mediations are half a day or a day. We mediated over about a 3-day period of time. By the time we ended up, my clients were convinced that the other side was sincere about wanting to have ownership of the technology. And the other side was convinced that it was important enough to them to offer enough money to my clients that they were willing to redirect their professional careers by selling their technology. And outside of a mediation context, I don't think that would have ever happened. And so, again, these folks had a chance, even though they were highly educated, sophisticated, PhD and post-PhD people. There was still the emotional aspect of being able to tell their story and to explain their position and to try and convince. This one involved, I think, 3 other parties, the university and a couple of other parties. Tell their story, think about what made sense, come to a voluntary agreement about what made sense, go away feeling satisfied if not happy about the outcome. And if we had done a jury trial, it probably would have lasted a month. We did a mediation and it lasted 3 days. And from society's point of view, it was obviously just a superb way of solving the problem.
Let me ask you a question about that. How do you keep the atmosphere so that either the other side, both sides actually hear the other's interests and needs in a mediation?
Well, most mediations that I'm involved with now, there is not much, if any, direct exchange from one party to the other of views. It all goes through the mediator. The mediator carries the message. And that is so because while it's useful and helpful for the parties to express their feelings and views and tell their stories, it generally speaking is not helpful for that to happen where the other side can hear it and get angry about what they're listening to. Again, one of my earliest, the mediation that I referred to a moment ago, where there were like 8 parties. At that time, at least I think in this state, certainly in this community, the conventional view was that you would start a mediation by having each side, either directly or through counsel, present their case, briefly, but present their case. And so we spent a whole day. One of the federal courtrooms was made available because there were so many people involved, between witnesses, party representatives, lawyers, insurance carrier representatives, and so forth. We actually went over to one of the federal courts, and everybody did a dog and pony show. We had graphic aids, we had stuff on the TV screen, and we got up and we made closing statements. And by the time that day was finished, everybody was so angry it was highly doubtful whether we were going to actually successfully mediate the case. We ended up working at it for another 3.5 days after that, which is how long it took to kind of calm everybody down. But so a lot of mediations now don't involve that sort of preliminary exchange of positions because it tends to be, I think, counterproductive. Not everybody agrees with that. Sometimes if you've got a party, an insurance representative, for example, who is not directly emotionally involved, it's useful to have the plaintiff or the plaintiff's representative, lawyer, whatever, trying to explain to the carrier's representative, this is what we got, and this is what the case is going to look like, and this is what a jury is likely to do. But generally speaking, if you've got the two clients on the side, this exchange of views happens through the mediator. He does shuttle diplomacy. He or she does shuttle diplomacy.
Can you show weakness in a mediation? I mean, if you know that something isn't in favor of your client, can you do you still keep that from, I mean, how does that work?
Well, a good mediator requires and works to get the parties to acknowledge their weaknesses. And so the mediator, the lawyer representing the party in mediation, I think, tries to communicate that that party is aware of the weaknesses and acknowledges them to exist, but that's why they're willing to compromise, and therefore it doesn't result in further deterioration of your position or reduction of your expectations.
A couple more questions on this. How did the first, because you have here 3 intellectual property cases that are sort of similar.
Yes.
How did the first one, what did you change from the first one to the second and third one in terms of your approach once you got?
That's a good question. The first thing that I changed is that I sued fewer people, so that I didn't have quite as much of an army of law firms arrayed against me the second time. And the second thing that I did was to try and work towards a much more prompt mediation. In the first case, we just filed a lawsuit, we beat back motions to dismiss, and we set off around the country taking depositions and kind of headed towards trial. And one of the other party representatives then suggested mediation. And in the second and third cases, I'm not going to say that I was the only one that suggested it, but very quickly we moved towards the thought, well, why don't we do what we can to gather the necessary information to be able to mediate rather than to do the full discovery that we would need to do to prepare the case for trial.
What?
In other words, we didn't do as much. We did selected document exchange. We did selected depositions. We tried to key on what would be the most influential issues or factual areas that would tend to make the parties have a realistic sense of what was likely to be the outcome if we went to trial.
To do mediation, then, do you have to have all the parties involved be willing to do it, or what
Yes.
happens?
It's an entirely voluntary process.
And do you feel like if you go to trial, you're giving up information, or do you feel like it hurts you at trial in any way if it doesn't work out?
Properly done these days, litigation requires a full exchange of information anyway. So I've never felt that was a reason not to mediate.
Okay, what's the difference then in your experiences with arbitration?
Arbitration is not voluntary. At least once you get into it, it's not voluntary. One of the things that I tell my clients to try and convince them that mediation is desirable is, look, we agree who the mediator is going to be. We agree to some ground rules for exchange of information. We get into the room, we start working it. Anytime we're unhappy, we back away and say, I'm sorry, it's not working, we're going to go to court. Arbitration, you agree, you select the arbitrators, and then you're stuck. The arbitrator is going to decide the case in a way that you may or may not like. The arbitrator is going to decide the case in a way that, with 4 very narrow exceptions, cannot be appealed. And the arbitrator or arbitrators, oftentimes there's a panel of 3, they're not a jury. They're by and large going to be either lawyers or accountants or sometimes scientists or engineers, depending on the topic for the arbitration. So it's I like arbitration in many instances, again, because you can achieve a resolution to the case less expensively and, generally speaking, more expeditiously. I'll give you 2 examples of cases right now. In one case, I'm representing an individual who has a substantial claim which is strong in equity and not so strong in its legal underpinnings. And he's also now wanting to spend a lot of time and effort and money to take it all the way through the court system. So we said, okay, there's an arbitration clause in your essential agreement, we'll take it to arbitration. And so that's going to serve the client's needs, because he's not entirely sure whether the game is with the candle. If he has to do a full jury trial, and be subject to an appeal. The other case, I just was talking this morning with one of my partners. The client has a beef with a large corporation, and there's an arbitration clause, and the law is probably strongly against the client. But if we can get it to a jury, the jury probably would strongly agree with what happened to our client and would look for a way to provide relief. So the first thing that we did was to read the Arizona arbitration statute in the cases and take a look at our proofs and then say, do we have a basis upon which to attack the arbitration clause? And if we do, then we're going to go to a jury, and we think the other side is not going to like that, and they may be more willing to come to a reasonable compromise. So, and that's the arbitration provisions are, they serve particular needs of particular kinds of cases.
So if you're creating a contract, and you could have anything you wanted in terms of whether it was an arbitration clause or no arbitration clause, or could you have a mediation clause? What would be the ideal thing, and would it make a difference in terms of the situation of what the contract was, or what side you're on?
Yeah, it makes a difference what side you're on. If you're creating a contract for an organization that's going to face repetitive kinds of claims, broker-dealers, automobile manufacturers, large corporations, generally you're going to want the arbitration clause because overall it reduces your transaction costs. If you're doing a one-time deal, then it's much more individual determined. It's much more what's our likely position in this particular transaction, and would we want to be in front of a jury, would we not?
So with a client, then do you try to, or before you see or sometime in the process, do you try to figure out what possibly could go wrong with with a contract to figure out, how much speculation?
To be honest with you, I have to tell you that I haven't written a contract in so long I can't remember.
So you don't have to worry about that part. You just
I
get
haven't
when
done
things
anything
go
but
bad.
litigate for longer than 25 years, I think.
Oh, okay. Well, then let me ask you another question. There's all these different, I think now I'm getting tested on what I've learned in international commercial transactions. There's different arbitration, AA,
True.
all those. That maybe you could talk about your experiences, what you think about the differences, and if you've arbitrated under what you've arbitrated under in terms of the rules.
Sure. My experience in arbitrations is principally related to two different bodies. One is the National Association of Securities Dealers, NASD, and those are customer complaints. And the panels are constituted out of theoretically two public members and one industry member. As a practical matter, even at least one of the public members, and oftentimes both, will be either retired members of the industry or lawyers who have worked in the securities customer claim area. And so you tend to get people who know the subject matter pretty well, and they know sort of the customary behaviors of both the broker and the client, and it's a fairly clearly defined kind of a set of circumstances that you arbitrate various individual cases within. So you get a sense of what's the kind of documentation that's going to be significant to use as your exhibit or cross-examine on. What are the kinds of stories that a customer or a broker is going to tell that aren't going to float, or that will float, that have arbitrator appeal or don't have. The American Arbitration Association is a good deal broader. It has rules for commercial arbitration, it has rules for construction arbitration, it has rules for employment dispute arbitration, and there may be some other rules. And you get a panel that tends to be a little bit less predictable in terms of their background knowledge and the viewpoint that they bring to the table. And then I've got one right now which is under the auspices of the National Association of Healthcare Lawyers. At least that's what they were called at the time that the process was set up. And they have rules that are very skimpy, so we're going to probably be making it up as we go along in terms of what kind of discovery can be done or cannot be done, what kinds of pre-hearings are done, how the hearing is going to proceed, and so forth. And then occasionally you do an arbitration that's just, there's a clause in the contract that says, we'll pick an arbitrator, you pick an arbitrator, they pick an arbitrator, and we'll go do it. And I've done one of those. And it was not as different as you might think, because while arbitration, to my experience, was originally intended to really sort of short-circuit the kinds of procedures that one would do even with a court trial, as a general matter, there tends to be more discovery than I think the creators of arbitrations ever intended there to be, and it tends to be more formality at the table in terms of witness testimony, cross-examination, opening statements, closing arguments, and so forth. It's just sort of the mores of the culture of arbitration. That's kind of the way it's been. It becomes like a bench trial, except oftentimes with more than one judge, and around a conference room table instead of the more formal setting.
All right, I got 2 questions for you.
Okay.
Do you like, I mean, you talked about there, let me see how there, on the one hand, there's the NASD, that's
Right.
really well organized and very sort of everything's, and then you've got the very skippy one that you were talking about. Do you have a preference in terms of working? Do you like it when it's super organized, or is there pros and cons to it?
Depends on which side of the case I'm on. The case that has the skimpier rules right now is also the case that my client and I want to push it on through and get it done with a minimum fuss and bother. So that was great. The NASD is suited for the NASD, well, for the sides of the NASD cases that I do, because I tend to represent the broker-dealer. And they then know, if they get a customer dispute, what to expect, what the arbitrators are going to be looking for, what documentation they should keep, what files they better have. It's predictability of how the problem is going to be resolved.
All right, and here's one. I don't know if you want to answer it or not. I worked with Professor Gantz this fall on arbitration for NAFTA. I was one of his assistants, and so I saw it from that side of the helping with the briefs. And I was just curious if you had any thoughts about sort of arbitration being used in the international context to solve problems between companies and countries, and that there isn't really the trial as an alternative. I mean, I guess there is in some way, but if they go to the national level. But I didn't know from your experiences with it. If you
I haven't done any international arbitrations. The sense that I have is that it's probably a good thing institutionally, because very few other countries really have a belief in the validity of the jury system for the resolution of civil disputes. And so I think it probably, the availability of commercial international arbitration is probably at least incrementally an aid in promoting further commerce between various countries in the United States, because they think, well, we don't have to go through that scary American jury trial process that's so unpredictable.
All right, we're going to shift gears a little bit, if that's okay, unless you have something
Nope.
else. Okay, now we're going to more personal questions and sort of fun questions, if
All
that's
right.
okay. First, what do you think? I mean, these are hard questions, so you can just say, I don't want to answer that one if you don't want to.
All right.
Do you have, like, a lot of people have been talking about, well, some people have been talking about sort of the place of law in their life, in the sense of, like, do they see it as sort of, I don't know, they all have very different views of it, and it's really hard to sort of say. So I don't know if you have a sort of philosophy of sort of what you think the law is, or what it should be, or the place it's had in your life in terms of, and that may be too hard a question. I can ask other questions too. Some of them were talked about sort of their own personal sort of their personality sort of dictated what they did, or sort of their personal beliefs of what the world should be like. It sort of motivated them to do what they do. I don't know. It's a hard question.
Well, that's an interesting question, and it's not one that I've ever been asked before. But I think I understand what you're getting at least. It triggers a reaction in me. I started out to be a military officer. I went to a military academy, and I expected to make a career of being a military officer, except I took 2 law courses at the academy and performed far better in those than I did any of my other ones, so I started getting interested in doing them. But what probably was the most influential in my choice of the law is that I came from modest background. My family was not influential in the communities that it lived in. I didn't feel like I was a particularly important. I didn't feel necessarily unimportant, but I didn't feel like I was anybody. And I looked at the legal system as one that would have a process where somebody who had a difficulty with society or with somebody else would have somewhere to go and have his or her voice be heard. It was a system that could be worked to protect the individual. And that was persuasive to me. That was interesting to me. There's a system of rules, not just substantive law, but the courts and the procedures and so forth, where if there's some little person who is being abused, they've got somewhere they can go, and a lawyer can go help them. Although you can turn it around, there was a certain amount of anti-corporate mentality among the members of my law school class when I went to law school, that it's better to be the little guy, and the corporations don't deserve all the lawyers that they can buy and so forth. And I think the principle works just the same way. If whoever is the disfavored litigant can turn to the law and the procedures and have their positions protected.
And do you still feel that way? Do you think that it's...
I do. It's probably a little bit more of a ad hominem institution than I believed at the time I went to law school, but it's still amazingly, I think, a system of a rule of law rather than a rule of men and women.
Interesting. Could you describe what your day was like when you first started versus what your day is like now as a lawyer?
Okay.
I know there's not really a typical day.
Not as much different as one might think. Again, because when I started practicing law, I was asked to get involved in a lot of different kinds of cases and legal matters. And so I didn't go away and research for 3 days. I mean, I may have done that from time to time, but typically my beginning practice was not having 1 or 2 or 3 cases and spending gobs of time or being in the background. I was fortunate enough to be involved in interaction with clients, witnesses, and courts, pretty quickly. The biggest difference now, I suppose, is that I feel as though I have an intuitive talent that I didn't have at that time, that I can perceive problems and conclude how to attack the problems a lot more easily and quickly, and therefore have a sounder basis to turn around and involve a junior associate or a senior associate or a partner and say, this is the way I see it, let's go attack it this way, and they go away and do a lot more of the extensive work than used to be the case. There was a long period of time where I was fortunate enough to get more and more responsible kinds of things, but I still felt like I wanted to be reading all the cases myself, interviewing all the witnesses myself, doing all the stuff. And I feel like in the last 5 to 10 years I've gotten, and I may be a slow learner, there's probably a lot of people out there who figured that out after the first 2 years or something, I don't know, but I feel like I've gotten from the continuous experience of cases, all of which are different in some ways but present similar kinds of human situations in others, that you get a sense of the intuitive way to approach a legal problem.
Now, you've done tons and tons of different things, and if somebody wanted to do that, do you think they can still sort of find a place to be able to do all kinds of things, or do you think that the world's become more specialized?
I think the world has become more specialized. I'm not going to say it's impossible to do, but I have had peers both here in town and within the state and out of state, remark on the extent to which I've been able to do a whole lot of different things. I think I was in the right place at the right time to do that. I think it'd be very difficult now. And you know, there's an attraction to doing that, but there's also, you know, another way to look at it. There are people who are very, very good at a particular, sometimes very narrowly focused kind of a practice, and then they can do the sort of intuitive problem solving that I just talked about a whole lot better and a whole lot quicker, and maybe provide more efficient and more prompt help to the clients than I can if I've got to learn about something, you know, and put it all together and figure out what to do and then go do it. So, I mean, there are people who do, you know, highly specialized kinds of financings, or highly specialized kinds of domestic relations work, or highly specialized kinds of immigration work, where they learn the law and they know the law right down to the last little nuance of a subpart of a subpart. And that can be very effective, and I think a lot of people find a great deal of satisfaction in that. I just tended, I mean, when I was thinking about going to law school, before I left the service, I came home on leave and I went to see a family friend who was recently admitted to the bar. And the main question I remember asking him was, you don't do the same thing every day, do you? And that was what was important to me.
I have two questions on that. There's a lot of talk about lawyers being really unhappy on what they're doing, and I think that scares students sometimes, like that they're going to end up somewhere unhappy. Do you have any thoughts about that, or how to keep from having that happen, or maybe if that's just, is that always, I mean, does the profession have a bad rap that people aren't, I mean, it's just become part of the culture almost. That
I don't know whether the profession has a bad rap. I think that there was an ebb and a flow in the demands placed on young lawyers. I think that into the 80s and 90s, the expectations were greater and greater, more and more of a young lawyer's time, less and less time for a life away from the law. And I think that has been refocused. And you know, I've been a member of 3 law firms over time. One was a mid-sized law firm for 21 years. One was my own law firm for 8 years. And now I'm recently in a 450 lawyer law firm, so my database is perhaps a little bit small. But my perception is that, and partly because of, you know, good old market forces, competition for the good people these days want to have a life. And so there is attention being paid to those expectations. And so I think that probably it's a little different now than it was, say, 7 or 8 years ago. I really do. On the other hand, the law is a consuming profession. If you have a problem, I mean, you know, if you've got a client who has been charged with a serious crime and you don't see your way out, it's not a hopeless case, but you don't see, you know, how to best advise the client, you can't turn your brain off, and you can't necessarily stay out of the library just because you've decided that you want to have a 40-hour week, because your concern for the client, your intellectual curiosity, your desire to be successful won't let you. So, I mean, to a degree, the law is a consuming profession, always has been, always will be. But I think these days, just in terms of the expected number of hours that young lawyers are exposed to, I think it's moderated to a reasonably substantial degree.
All right, here's another topic. When you get a client and you have a new client and you have a new problem, you don't know anything about it. What do you do? And I mean, you've done this so many times now. Do you have a particular system of working, or how you attack a problem?
Sure. To begin with, the client interview has to be a nice balance between keeping them reasonably on track, because you could spend half of your day finding out what the problem is if you let the client interview go completely unstructured, and yet not being so restrictive that you don't hear things that you need to hear that you wouldn't have thought to ask. So that's the first thing, is you need to get the story in a reasonably broad way with reasonable amount of efficiency in the time that you spent. And that may be an hour for some things, it may be an all-day meeting for others, but that's the sort of the tug and the pull is to hear the story, get to know the client, and so forth. And then what I always try to do is to carefully examine, and this is part of the client interview, carefully examine what the real objectives are, what the real problem is and what the real objective is. And oftentimes, and most of my work, my trial level work has been commercial litigation, and so it's, ultimately you're going to end up talking about money damages. And so one of the things that I have done that I frankly don't think that a lot of other lawyers do is to focus early on the causation and damages aspect of a case, because unless you know where you're going to end up, it's kind of hard to decide, just how you need to spend your time and attention, what witnesses you need, what areas of the law you need to dig into, and so forth. So a lot of people say, well, we'll get the story, then we'll research the liability, and we'll file a complaint, and generally allege damages, and then we'll figure it out. But, and this circles back a little bit to what we were talking about previously about mediations and problem solving. If you try to figure out with the client what the real problem is and what would be a good solution, then you can decide whether you need to go sort of conventionally through the process all the way up to a trial and so forth, or whether you try to go quickly to a mediation or to negotiate something or whatever. So that's the second thing. And then I come back and figure out what parts of the law do we need to fill in, and then sort of the fourth step is the strategy. Okay, how do we accomplish what we're going to accomplish? I have a work product that I call my opening file memo that I try and get my folks to use, and it sort of tracks those parts. It's the story, it's the nature of the claims or defenses, it's the remedy aspect, it's the sort of the theory of the case, which is not the legal theory, but this is the real life story. If you're going to try the case to a jury or even to a court, what's really going on here, and why is your side of it worthy of relief or attention versus the other side? What's your theory of the case, and then what is the strategy? How are you going to get to where you want to get?
And how does that change over time from the first?
It will, yeah, it will, sure. You've always got to be thinking. I went to a deposition in a real estate dispute on Friday of an expert witness, and the lawyer on the other side said, well, we got this other witness coming in later this afternoon. How much time do you think you're going to need to cross-examine? I said, oh, probably a fair amount of time. The guy asked a few questions and stopped, and all of a sudden, just like that, I had to decide, does it make any sense for me to ask any questions at all? And I said, no questions. And they said, what? You always have to be rethinking what you're doing.
And what made you decide no questions?
First of all, you have to think about, what are we doing taking a deposition? Sometimes people get caught up in the process. We're all here. We're going to ask all kinds of questions about the case. We got the witnesses. It's kind of like the process is the end result, but it's not. The end result is, what are you going to use that deposition for in the trial? The deposition was going to be used at the trial. This guy happened to be probably my eventual expert witness and not theirs, and they were taking his deposition. So the deposition would be used at the trial to impeach my witness after he figured out what he was going to say. They had not opened up enough questions that I needed to say anything, because all I would do would be to create more impeachment material. So I said, I have no questions. You take that sort of tactical consideration and you extrapolate it to a more strategic level in terms of how are we going to get where we need to get. Early in my career, I worked with one of my senior partners, well-respected lawyer, and I think we ended up with 12 amended complaints because our theory of the case kept evolving over time. I don't think you could get away with that these days, amending a complaint that frequently. But every time something new would come up, you would say, well, let's amend the complaint, put this in.
Okay, how do you learn, I mean, this is, say my question, maybe you can figure out how to answer it. When I hear you say that, I think, well, how do you learn all that? How do you figure that out? And I know it's experience and sort of figuring out what you want, but also what do you think the relationship should be between young lawyers and older lawyers? And do you think there is a mentoring process that's still happening, or do you think it should be stronger? And what should they be mentoring? Should it be that kind of thing, or should it be the law, or everything?
Absolutely, there should be a mentoring process. I don't think there's any question about that. Having said that, when I joined the firm that I did out of law school, or after I clerked, rejoined them after I clerked, there was no formal mentoring process. We didn't sit down and say we're going to talk about how to take a deposition or whatever. But we worked together on cases. And I would go seek advice if it was a case that I was not second chairing. I would go talk. I got this problem. I got that problem. What do I do? And in the context of solving problems, you learn stuff. Now I do, and the large firm that I'm now part of has a much more formalized training and I think mentoring program than that suggests, and that's probably good. But even when I had a small firm and I had anywhere from 2 to 5 lawyers working with me, what I would typically do is when we would finish some exercise, some court hearing, a motion hearing, a more complicated deposition, whatever the case would be, then we'd sit down and say, okay, what have we got, what do we not got, where do we go from here, and let's talk for a few minutes about why didn't I ask this question, or why did I ask that, or why are we taking this tack instead of that tack. So you sort of weave it into the process of representing the clients.
Do you think that there's this sort of feeling that laws become more business and the bottom line or billable hours and all those sorts of things matter more? Do you think there's less time devoted to that now, or do you think it's still happening?
I think it's still happening. I do.
That's great.
Yeah.
All right. Just a couple of silly questions and then I will be done.
Okay.
What is, now you don't have to answer any of these again if you don't want to, what is one of your happiest moments with regard to the law?
The moment that I concluded the argument in the U.S. Supreme Court of the case of Edwards v. Arizona. It was the first and so far the only case that I've argued to the United States Supreme Court. I was understandably very concerned that I do a good job for a lot of reasons. I worked on it and worked on it and worked on it. And as luck would have it, I felt like I had done an exceptionally good job of presenting my client's case. And I felt good enough about it that when I stepped away, I wanted to turn to the lawyer behind me and say, give me your briefs, I'll argue your case too.
That's great. What do you do when you have a difficult client?
That's an excellent question, and I don't have a good, simple answer. And difficult is, there's a lot of kinds of difficult clients. I just went through an experience. It's the only time in almost 30 years of law practice that I had to ask a court to allow me to withdraw from representing a client in a case that was reasonably close to trial because of disputes and conflicts that I had with the client. And there were a number of things that I took away from that. Number one is to try always to keep myself, my ego, and my emotions out of the situation, because if they're not taking your advice, or if they're arguably at least misrepresenting to other people what you're doing or saying, there's a tendency to get emotional. And so the first thing you have to do is get a grip, stay professional. The second thing you have to do is to try and focus on the fact that the clients are clients, they're human beings, and you've got to give them the benefit of the doubt. But then the third thing you have to do is to recognize that you're an officer of the court, and you just sort of take the problem step by step by step, and if it deteriorates to the point where you have to take action, then you do so in a professional way. To answer the question as to a different kind of a difficult client, one of my most difficult clients was a murder defendant, and for a lot of reasons it made no sense for this client to take the witness stand and testify in his defense. And I was not able to convince him that that was the case, and he did take the stand and testify. And every lawyer that I talked to about the case agreed with me that my advice was right. So it was, I mean, objective observers would say this was not a debatable deal. I did not have the client's confidence. I didn't have the client's, deep, solid confidence. Now, there were reasons for that, which I could get into, having to do with previous counsel on the case and so forth, but that's neither here nor there. What I needed to have done was to realize that I hadn't spent enough time early in the relationship building that trust and confidence. So what I say about difficult clients in that sense, not clients that you think are violating the rules or whatever, but that they're just very emotional, or they're very, they're very uneasy about things or whatever, is that you have to gauge the importance of the relationship and how much work the relationship needs, and probably you need to think about that at the beginning when a client comes to see you and say, okay, is this a client that I can feel comfortable representing? Not necessarily because you agree or disagree with the particular kind of case or the kind of defense that they have, but just their overall, the nature of their problem, the nature of their personality and your personality. If this is somebody that I can really represent as a client, then I can be, attentive to their concerns and just spend the time to build that relationship.
I want to ask a couple more questions about that. That's one of the things DMSR also really is interested in. I guess my question is, how do you gain a client's confidence? Does it change from client to client? And also, well, there's a lot of material written on sort of, I mean, you talked about this before, sort of the goals of the client and what they really want, and sort of the cultural differences or the sort of the place that they're at, and sort of maybe could you talk just a little bit about that?
Yeah, and I don't know. I'm not sure you can always get the client's confidence. I just came from a client conference with people that I'm getting along with very well, and they're listening to our advice and so forth, but on a couple of really important points, they're not going to, they're going to make up their own mind in a way that doesn't accept our advice probably. So it's not always attainable. But number one is you pay attention to them and you let them know that you're aware of their problems and them. You return phone calls, you get the facts down, you don't come back and say, now tell me what happened again. You just basically let them know that they're on your radar screen. Number two, I think the core concept of competence is important if you're, perform competently. Number three, as I've already alluded to, you take the time to try and keep them informed and to work with them. If there's an important deposition, you don't bring them in 15 minutes ahead of time. Even if you could probably do what you need to do in 15 minutes, you do it far enough ahead of time so that if they have any questions or problems, you can find out the answers, or you can revisit something with them. So you structure your interaction in such a way that you have the opportunities for the contact and for the communication with them.
Well, this has been fantastic. Do you have any other thoughts or ideas, or
now you know all I know.
Done? Yeah, right. Well, thank you again so
You're
much.
welcome.
It's been
I'm
great.
happy to do it. I
This
hope
is
the
great.
project